methodical approach to trying cases and investigating cases. But I remember watching Brett do a closing argument in a murder case that he got an acquittal in, and Brett's argument was just like Podolsky. It was fiery and fighting, and it was very methodical and well thought out. So I thought Brett had something to give as well. So next up is Brett Podolsky.
Good afternoon, everyone. We're trying to make sure this other TV, we got that, there we go. I'm going to try not to retread a lot of what has been talked about, although there's going to be some retread. But I do want to say that when I put up there one lawyer's perspective, I really, truly mean that. I truly mean that this is my perspective. This is what I found works for me. As far as how I try a case, I have, peculiar tailoring needs, as one person described. And so the way I do things, is really narrowly tailored, or maybe not so narrowly, to me. And the way I try a case, the way I argue a case, is how I do it. It may not work for everyone, but this is how I do it. It may be sometimes there are those that would argue that I can be a little snarky and maybe aggressive, but I'm going to start with just a 10-second piece of video footage, which would be my dream argument.
Everything that guy just said is bullshit.
Someday in my life, I would like to do that. But I want to talk about what I think closing argument can achieve, and what I don't think, more importantly, it can achieve. I do not think that closing argument is going to flip the script. I think that what I'm going to talk about is not, a lot of us have been in cases, especially a lot of capital lawyers. I'm not talking about the slam dunk Whale Rider States case. I'm not talking about capital murders where you got confessions and DNA and fingerprints and everybody's lining up to testify how guilty the defendant is. It's just that the state's offering you an automatic life sentence and you have no choice but to go to trial. Or, as is often the case, you have these drug cases. The guy's a habitual offender. He gets caught, arrested. He's got, the drugs, in the crack of his ass, and it's, there's nothing you could do, but because he's being offered 25 years on a 25 to life sentence, and you have to go to trial, and you do the best you can for the guy. I'm talking about the thousands and thousands of cases where there's meat on both bones. Hopefully, your bone is meatier than theirs. Now, what you can't do in closing argument, you are not going to steal victory from the jaws of defeat, in my opinion. You're going to have won that case by the time you get to closing argument. I believe that you win the case, certainly in the juries that you select, but as far as a not guilty is concerned, you're going to win that case in cross-examination. What I believe, as far as closing argument is concerned, you're going to convince the jurors that are with you, and hopefully there's going to be a lot of them, to dig their heels in, to dig those trenches even deeper, firm up their resolve. You're going to try to convert the fence sitters, and there's going to be fence sitters. They're, they came there, their heart, just believes that, they're in criminal court. The guy's charged with a crime, certainly guilty of something, and so, they're kind of spring-loaded to convict, because, why else would they be there? So, but, man, the defense lawyer made some good points. Those, you're talking to them. And then, of course, you want to weaken the resolve of the jurors that may not be against you. Meaning, you're probably not going to swing them to say, man, this guy's innocent. But they're probably, at some point, going to throw their arms up and say, fine. You know what, fine, I'll vote not guilty. Maybe they didn't get there. Defense made some good points. We've been fighting it out long enough. That's how I kind of think that it goes. I mean, I've had some cases where I believe that it was done. By the time the state rested, I mean, it was over. You could just look at the jury and tell they were done. They were really closing arguments for both sides. They had already made up their decision, and it really was just an exercise for the lawyers to hear themselves talk. That is some of what closing argument is. I don't want to undermine the importance of it, because there are times in closing arguments where we could really nail the prosecution. If you're smart about holding things back in closing, not showing every one of your cards in closing, because if you have a really good piece, for example, like an inconsistent statement that's already somewhere else in the record, or a piece of contradictory evidence that you know is already in the record, you don't always want to ask a witness directly about it. Drop it on them in closing where they can't respond to it, where the witness can't make it, some excuse about it. Oftentimes, police officers. Always be closing. From a trial, from the opening, the second you walk in there, when they start shuffling that jury panel in, you are closing, you are formulating your closing arguments from the second you walk in there. I'm talking body language, obviously, David talked about, having some client control and really talking to them about how to behave. I got some stories about that if we have time for it, but you really want to always be portraying the position that the guy sitting right here, is often the case, gals too, and in fact we're going to talk about a case, is an innocent person. I personally, I have a hard time arguing reasonable doubt. Saying, this isn't reasonable doubt, and this doesn't, amount to reasonable doubt, and, ladies and gentlemen, they have to prove the case. It just doesn't work for me. It's not that I don't talk about things involving reasonable doubt, but I just don't use, sort of the terms out of the jury charge. I just hammer my facts. Be passionate. Be passionate from the get-go. There are, when I sit and watch trials, when both sides, prosecutors and defense lawyers, are just kind of, they're talking in just moderate tones. The juries, they want to see a show. Especially nowadays. This is the era of making a murderer. I personally think that we are in the golden age of defense lawyers and defense practice and criminal jurisprudence from the defense standpoint. People have watched that show, and it is all about the defense lawyers and the villainous prosecution. And that's kind of way that people, that for whatever reason, that show resonated with people, and it really is all about these two defense lawyers, putting on a case against all odds. I'm not, did the guy do it or not? Who the hell knows? But it resonated with people, and people that would otherwise, not be buying into the whole, you're just the defense lawyer, you're paid to make these, bullshit arguments or whatever. It resonated with people, and I really do think this is a time to put on the show. Obviously you don't want to look like Barnum and Bailey, but you really do want to keep them interested and show some energy. But you have to be able to sell it. That you believe that the person sitting at counsel table is an innocent person. And if you can't sell it, you're done. If they think at any point that, I'm here to, represent my client and make sure that his rights are protected, that's not going to get you anywhere. This is something that you guys really should do. I hate watching the state put on their case. I can't stand listening to their closing arguments. Honestly, it's the same arguments and nonsense you hear over and over and over again. They all go to the same, CLEs. They all listen to the same division chiefs that tell them to make the same arguments. Use these arguments against them. You're talking to the jury right here. They're going to come up there and they're going to start pointing fingers. When I'm up here and they're sitting right here, I'm like, the prosecution wants to have, you start pointing fingers at them. And what I like to do, I like to make my argument right here, behind them. behind them. Start talking to them, because they do that shit. They start getting hot boxing your client. Do that to them. And let me tell you something. It makes them very uncomfortable. And the jurors see that. And they don't want to see prosecutors looking uncomfortable, because they want them to seem really confident about their case. And when they start getting all squirmy because you're arguing, really getting close to them, getting in their personal space, even better when you're talking to them from right here, they don't like that. They're not used to that. Okay? And that can work. Be the 13th juror. If you have alternates, be the 14th or 15th, but be the 13th juror. Ladies and gentlemen, you have questions in this case. We raised a lot of questions in this case. And you're not allowed, unfortunately, you don't get to hold up little signs like they do on Dancing with the Stars where you can hold up the number, you unfortunately can't ask questions. I would love it if you guys had these you can write on pads and hold up. Either, as oftentimes the case, move along, we got your point, you're wasting our time, which does happen. Or, hey, what about this issue? We want to hear more about this. So I'm going to ask some questions for you. Matt, prosecutor, how come you didn't, swab for DNA at the time? I'll give you an example of a case. Matthew, who's sitting right here, we try a lot of cases together. We tried an aggravated assault of a public servant case where and if anybody is in here, there's a co-defendant that's going to trial really soon. So pardon my arguments here. We tried the first case. It was a husband and wife that were accused of just beating the living hell out of this social worker that came to the house to try to take their baby. Anybody know anything about that case? Raise your hand. Is there anybody is on that case right now? Right. So Joe knows all about the case. It was a bad case. I mean, this little social worker, her name was Stephanie Vera. She was beaten within an inch of her life. Almost choked to death, was choked to unconsciousness multiple times, had head injuries, concussions, like golf ball sized knot on her head. It was really bad. The petechial hemorrhaging, all the ligature around, it was really bad case. And I represented the young woman, the mother of the child, and there was the Troy Davis is the defendant, was the father of the child. And man, when we picked up the case, we were like, oh my God, it was a very difficult case. It was, the police literally were banging on the door as the assault was occurring. Came inside the house as the social worker was crumpled on the floor in this tiny little shitty apartment. There's all kinds of, goofy stuff that was going on, and the defendants were some interesting folk. The husband had purple hair, and they were into all kinds of weird stuff. I represented the wife, and one of the issues that we dealt with was, they rushed and this was an assault. This was not sexual assault. This was just a beating of this woman because she wanted to, take the child away because they thought the conditions were filthy and they weren't taking care of the child and other stuff. They immediately rushed her to the hospital. And in the first case that I've ever seen this way, they did a SANE exam on the CPS worker. Even though there was no allegation of any kind of sexual assault or any sexual contact at all. But they wanted to be super thorough about the investigation. They wanted, to dot the I's and cross the T's. And so they brought in the SANE nurse, which is, I know, not the way you're supposed to say it, because it's sexual assault nurse, examiner nurse, whatever you call her. The nurse, who I have cross-examined I don't know how many times on cases, because she's Tiffany Dusang. Raise your hand if you've dealt with her. She's like on every sexual assault in this town. And she talked, she got up on the stand and she talked about this was the worst choking assault case she'd ever seen, the petechial hemorrhaging, the ligature marks, it was so violent. She was probably within seconds of being killed from loss of oxygen to the brain. Now, we knew, because I know this nurse, and I know that she is, just spring-loaded to give the state whatever they wanted. And Matt and I figured that they were just going to go to town on how awful the assault was. Now, the way the assault was alleged to occur, she was first attacked by the husband, beaten and choked and strangled, and in and out of consciousness. I saw the light. I was, my things were going blurry. I came back, and he was beating me again and throwing me around. And then I ended up crumpled on the ground. And then my client, the defendant, came over, and she got on top of me, and she was choking the hell out, and that's how. And then I heard the banging, and then she passed out again, and then, she was choking me more. And then the police were banging on the door, and they finally came in and saved the day. And when the nurse was just going overboard about how awful this was. And one of our things was just like, but you did the full SANE exam, and you and I have been in court together, haven't we? Yes, we have. And, you routinely, you had a SANE kit, right? A rape kit, right? Yes. And in that rape kit, you have the swabs, and you have the lifts, and you have all the things to take evidence suitable for DNA comparison down the road, right? Yes, and you knew, because you interviewed her, because in your SANE report, you always ask her what happened, that my client was supposed to have choked her. Is that right? Yes, absolutely. So put her hands on her neck, was on top of her. Yes, that's what she said. Well, did you make use of any of that DNA, any of those swabs, any of those tape lifts, to see if you could corroborate her position that my client had hands around her neck, that my client was on top of her, that my client had contact with her? Either did you collect her clothes? No, we didn't do any of that. We don't do that. This was an assault case. I was just, but you understand that you're there for the purpose of collecting evidence to prove to a jury. Now, I'm going to jump over